I'd like to bring the June 26th meeting of the Complaint Committee of the Sunshine Ordinance Task Force to order. Please call the roll.
Apologize. Member Hinsey?
Oh, sorry.
I have two mics now. Present.
Member Hinsey present. Member Wolf?
Present.
Member Wolf present. Chair testify?
Present.
We have a quorum.
Thank you. Will you call the first item?
First,
Second item. Yes.
second item. Approval of the May 22nd, 2018 Complaint Committee minutes.
Do we have a motion to accept the minutes from May 22nd, 2018 of the Complaint Committee?
So moved.
Second.
Will you take that with public comment, please?
I spoke under public comment at that meeting. Even though I didn't submit a summary, I think it's great that you just didn't say that, a one-sentence summary, that you actually kind of got into the facts of what I said.
Thank you. Are there any other public comment? Seeing none, can we take that item by acclamation?
Sure. No objection.
Thank you. Can you please call item number 3?
Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
The timer.
How do I get this to... There used to be a button here. Members of the Complaints Committee, whoa, jeez. Member of the Complaint Committee, I was just going to get up here and say, Members Hinsey has 2 microphones, so she's in stereo, and here I am, hydrophonic sound or something. Anyway, you all know me. I've been coming here for years. It's been a decade now since I first started back in 2008. And the list of complaints I have where I've actually gotten orders of determination is up here. It's an even 3 dozen, and I'm kind of taking a rest so far. The interesting thing I'd like to point out to the Complaints Committee, though, is the fact that there is a method to my madness. And one of the things to remember is all but 6 of these have to do with one subject, and that is the Friends and Foundation of the San Francisco Public Library. It's a fraud. It's a scam, it's a con, and it's done and was done. It was perpetrated and perpetuated by former city librarian Luis Herrera. The public records I have obtained and the public records that they have disclosed let me know that over the years that I have been following this, they have had more than $80 million pass through their hands. And in the best years, 10% of that went to support the library. They are right on the city library's website. It says, want to support the library, and there's a link to the Friends. So basically, they suck people in, and they convince them using government facilities, government publications, to convince them that if they give money to the Friends, they're giving money to support the library. In one particular year, at the height, they raised $8.5 million, and the library actually got 6%. The original approval for the arrangement went before the Board of Supervisors when Luis Herrera first became city librarian, and they refused to approve it because they said that the Friends were not giving enough of the money raised to the library. And so basically, what happens is the city librarian just did a personal agreement between himself and the Friends. And then we took him to the FPPC in Sacramento, and he was accepting thousands of dollars worth of stuff from the Friends each year and then writing on his statements of economic interest for years that he was receiving nothing. And they found him in violation of state law, and obviously they don't like this. as I was just telling someone, the one accomplishment that I have gotten from all of this is the fact that the Friends no longer come to the Library Commission meetings. They used to come and lie to the public and talk about how great it was and how much of a benefit they were to the library. And the bottom line is they don't even come now, except occasionally they will sneak in during general public comment. And after I've made my comment, they will get up and the executive director will get up and say something like, well, I don't know where Mr. Hartz gets his numbers. He's confused or whatever. I don't know any reputable organization that raises funds, especially from the public, that would allow someone to get up and call them a fraud and call them a scam and call them a thing and not do anything to prove that wrong. And they don't. The Library Commission doesn't do anything to prove me wrong. The library doesn't do anything to prove me wrong, and that's because the figures are there and I'm right. And you see it on the time, mostly the ones I've seen lately are ones that are supposedly raising money for veterans. And then you find out that 90% or 80% of the money is going for their overhead and their rent and cars and trips and parties for their staff. And very small amounts are going to actually help veterans. The Friends of the San Francisco Public Library is a scam, and it was run for years by Luis Herrera. And I have asked the Library Commission recently, as they're now looking for a new city librarian, are you going to tell the new person that applies for this position about the scam before they accept the position? Or are you going to wait till their first Library Commission when I get up and call them a scam, a fraud, and ask the city librarian, the new city librarian, why he or she is participating in it?
Thank you. Is there any further public comment?
There seems to be some question with the task force as to me harassing the Arts Commission. That is absolutely not the case, and especially Vice Chair Hyland. He makes these types of allegations. We don't need to hear any more of the video. We don't need to know what took place. I want to recount to you an incident that took. I have never been to their offices. I only see them at hearings here in City Hall, and you see that I don't even speak to them. On June 15th of this year, on Market and Spear on the sidewalk, I was just standing there about 8 a.m. A woman came up, put a cell phone camera about 6 inches from my face, a little bit taller than me. She flashed off 2 photos. I said nothing and took up my cell phone and videotaped the entire incident. She said, and I quote, "Don't shove me." "What? You shove me? Stop touching me. You shove me. I have to call police and file a report." If that had happened, my camera would have shaken. There would have been some indication of this thing happening. Once again, she stood within inches of me, and she made a cell phone call, which was not to the police non-emergency number. So I didn't know who the woman was. She didn't identify herself. And I showed the video to someone else who identified her as Ann Trickey of the San Francisco Arts Commission. Later that day, I filed a harassment report against her and dropped off a flash drive with the video of the incident on it. I found out later that very same day, June 15th, Ann Trickey filed an assault report against me. This is a false report. There is no evidence of this. There were no witnesses to the event. If she had been assaulted, one would think that she would have called 911 immediately, or even the non-emergency phone number and waited for police to arrive. That didn't happen. 2.5 hours later, she filed a report in the Tenderloin Precinct station using a name that I haven't used in over 20 years. So I feel the burden is on me to clean up the mess that she created. Their claim is that they have no documents relative to their constant allegations against me, and that they're in almost constant consultation with the city attorney's office. That is not true, because these events are invented. Thank you.
For the clerk, Mr. Boo is that a statement to include with the minutes? Okay, so if the clerk could pick that up.
Okay. She has a written statement.
Yes, it's right there on top of the podium.
Yeah.
Is there any other further public comment? Okay, seeing none, item 3 is closed. Public comment is closed. You could call item 4. Thank you.
The complaint committee shall hold hearings on file.
You don't need to read that part. Just
Okay.
read item 4, please.
All right. Item number 4 is file number 17086, complaint filed by Ray Hartz against Dennis Herrera and Brad Brucey, Office of the City Attorney, for allegedly violating Administrative Code Section 6721I by acting as legal counsel for city employees or any person having custody of public records for the purpose of denying access to the public.
Will the petitioner please approach? Can you put his time up on the timer? Thank you.
That'll be 5 minutes.
5 minutes, yeah.
Members of the Complaints Committee, Ray Hartz, Director, San Francisco Open Government. On the overhead, you will see the same list I showed you earlier with the exception of 2 changes. One is that there are 10 of these that are highlighted in red. Those are all findings of violation found by the Sunshine Ordinance Task Force against the library and or the Library Commission. There are also 2 in blue. One against Dennis Herrera, City Attorney, and the other against Jessica Paula Jessen, who was acting at that time as the city attorney's, what do they call it, supervisor of records? Yeah. Supervisor of records. And I petitioned twice to get information from the library, and she denied both petitions. And finally, they did give me the information. The library was found in violation, but Paula Jessen was also found in violation because she denied the petitions to release the documents when it was very clear they were public records. So this has been a long drawn-out history, and it continues till today. One of the most recent cases was this order of determination. I made a request of both the San Francisco Public Library and the Police Commission for certain public records relating to Library Commission meetings and the cost of having a San Francisco police officer present at those meetings. The police department refused to give me the information. The library said they didn't have it. And the police department said they would not give me any information unless they had a direct request from the library. At the next Library Commission meeting, I asked to speak to Mr. Rusi and Ms. Blackman. They both came down off the podium, and I explained the situation to them. And Mr. Rusi, without a blink, said, she told you where you can get the records. That's all she has to do. And they both walked away. So I subsequently brought it here to the task force. The task force found that it was a violation. They directed the library to ask for the records from the police department, which they did, and the police department replied in 2 days. So I got the documents. But the bottom line is, throughout the history of my time before the task force, the city attorney's office has never, ever done anything except stand in the way of public records requests, particularly of the library. And I think most of you members that have sat through any commission meeting or any task force meeting that related to the library will remember at some point in that meeting, the city librarian's representative, Sue Blackman, would say, "We're acting on the advice of the city attorney." So basically, the city attorney, I don't know what advice they're given. If you ask them, they're going to say attorney-client privilege, and basically deny you any information that they will give you. But I can give you a kind of general impression of how they look at this stuff. This is from the Bay Citizen. Mr. Dorsey and other city public information managers said they spent an extraordinary amount of time and resources complying with the ordinance. They described the task force hearings as a tedious kangaroo court. He also said this: Matt Dorsey, spokesman for the city attorney's office, said in an email, the task force has degenerated into a rogue, lawless jury that beats up on city departments and tries to get conscientious public employees fired. Now, when the city attorney's office goes out and publicly makes statement to that effect, it not only undermines the law, it undermines you and its enforcement. And the bottom line is, I think I have a pretty good case to show that whatever advice the city attorney is giving to the library in particular, it is not to comply with the law. And they refuse to deal, and Ms. Blackman has refused over the years to produce anything that would show that she actually was going by the city attorney's advice. So as I've said before, and I will say once more, it is questionable whether Ms. Blackman is actually telling the truth, whether she is actually asking the city attorney for advice regarding these records requests and is being told that it's all right to withhold public records, or whether she is making it up. I don't know. Perhaps the respondent in this particular case might be able to provide us with an answer, but I think it's pretty clear that the city's attorney's office is not supportive of the Sunshine Ordinance, is not supportive by extension, I believe, in either the Brown Act or the California Public Records Act, and will do everything they can to undermine anyone who goes to a public meeting or a public institution and asks for records they don't want the public to see.
Do we have a representative present on behalf of the respondent?
Excuse me. Good evening, task force members. John Cote, I'm the communications director for the city attorney's office. I would make one point quickly, and the matter that's before you is a very narrow and distinct matter. Excuse me. I would suggest that well, first, I'd like to refer you to our written response on this, which is on, I believe it's page 31 of your packet. But separately, the representations of Mr. Hart here don't appear to constitute any specific claim against our office. He didn't present any factual information alleging a violation of the Sunshine Ordinance. When we received this complaint through the task force staff, our assumption was that it was regarding a memo that Mr. Rusi wrote at the request of the library and provided that memo. I don't have the date right in front of me, but it is included in your packet. If the substance of his complaint is about that, there are 2 points that I would make very quickly. One is that the memo that we provided to the library did not address the issue of denial of access to public records. And as you note, Sunshine Ordinance Section 67.21I, which is obviously the section that Mr. Hartz is citing in his complaint against our office, notes that our office shall not act as legal counsel for any city employee or any person having custody of any public record for purposes of denying access to the public. That's not what this memo did. This memo addressed an entirely different issue, which was whether the Sunshine Ordinance requires the donor of a gift to the city to comply with the entirety of the Sunshine Ordinance. In the opinion of our office, that is not the case. What the ordinance requires is for, in this case, the entity was Friends of the Library, to abide by the gift disclosure requirements, but not with the Sunshine Ordinance in its entirety. So then the second point I would make is, even if our guidance did address denial of access to a public record, which is not the subject of what it was, but if you were to view it as that, our office would still not be in violation of the Sunshine Ordinance, because The charter specifically requires that our office serve as the attorneys for all city departments and agencies. Now, the city charter is the city's supreme law. It's essentially the municipal constitution. So it requires our office to provide legal advice and legal representation to all components of city government, including the library, obviously. The charter mandates that our office has an attorney-client relationship with city departments, and that mandated attorney-client relationship encompasses the full range of tasks that an attorney must perform for a client. Those, of course, include providing legal advice. So no other statute, like the Sunshine Ordinance, can supersede the city's charter. To the extent there's any conflict between the two, the charter prevails. Now, I want to note that our office is committed to the principles of open government. It's something that we have consistently maintained. But I would like to make the point clear that the Sunshine Ordinance does not require us or even permit our office to disregard our best legal judgment. The ordinance, can't compel our office to curtail our duty to render opinions that reflect our best judgment on the meaning of the law. So I would just close with this complaint lacks merit and should be dismissed. And happy to answer any questions you may have.
Thank you. Members, this is the opportunity for questions. Member Wolf, Member Hinsey, do you have any questions?
I have a couple of questions for the respondent. Can you repeat your name again?
Sure. John Cote.
John Cote. Thank you.
Sure.
You said that the complaint doesn't cover the entirety of the Sunshine Ordinance. Can you explain what you mean by that? I mean, what part doesn't it apply to? What do you mean by entirety?
I'm simply looking at the complaint that was filed by this individual, and it contends a violation of Section 67.21. So that would be the section that they're alleging that there was a violation of.
Right, and so you made a statement that correct me if I'm wrong, that the advice, was it the advice that you were giving to the person who had the custodian?
The library?
Right, the library or whoever it was that was specified for the request of information. That advice was specific or not in the entirety? Can you repeat what you were saying?
Yeah, I see what you're saying. That was not about the complaint. So the complaint alleges that our office violated a specific provision of the Sunshine Ordinance. Mm-hmm. And our position is that we were asked by the library to provide guidance about a completely different issue from the issue that this complaint was filed under.
What was that issue?
The issue that we were asked to provide guidance on was about Section 67.29, not 67.21. Mm-hmm. And 67.29 is questions about whether or not hold on, let me just refer to my notes to make sure I'm giving you a correct response. It specifically had to do with when the library accepts gifts from the Friends and Foundation of the San Francisco Public Library, and whether or not that third-party entity, in this case the Friends, had to comply with all of the provisions of the Sunshine Ordinance. So this is a separate entity, not a city entity, a third-party entity. The question that was posed to our office was whether or not this third-party entity had to comply with all of the provisions of the Sunshine Ordinance, and it was our view that that third-party entity did not. It's got nothing to do with a city department. It's a outside third-party entity, but that third-party entity did have to comply with the gift disclosure requirements of the Sunshine Ordinance.
Okay. So, I just to clarify what I believe the petitioner is bringing this complaint about is that the advice that you gave them about any part of the Sunshine Ordinance to potentially deny the public of disclosure is the complaint is that you're making a violation of 6721I for any reason that may be applicable for denial or withholding of information. And that implication by making that advice to give them information that they can deny or a disclosure of this would be a violation of 6721I. That's. I'm just trying to get some clarification based upon your testimony so we can understand it and then relay that to the full board. Our purpose only here is for a little bit of discovery and clarification and to figure out what we can present to the full task force to expedite and make it streamline the process so we don't have to spend hours trying to figure things out. We'll do that here instead. My next question was the memo that you sent to the library or to the Friends of Library, was this made public? Is this a public advisory?
It was sent to the library. It's certainly public at this point. It's included in your packet.
But I mean, prior to that, because usually we find that opinions that are made about the Sunshine Ordinance or for any other reason are made as a kind of a public advisory, like an advisory for all departments.
Mm-hmm.
Kind of
I mean, it does appear to be a public memo. It is not stamped, privileged, and confidential.
Okay. And would you claim that the California Public Records Act supersedes the city charter?
I mean, that's a legal opinion. I would have to check with our office on that.
Well, but you just stood here and told us that city charter supersedes Sunshine Ordinance.
Correct.
Sunshine Ordinance for probably 80% of it is the CPRA under 6721. And it makes very specific aspects to increase expediency and disclosure as allowed by state law. So, I find it a little difficult, and I want to also research to find out if the same provision under 6721I also applies at the CPRA. CPRA generally focuses on agencies, doesn't focus on people. The Sunshine Ordinance narrowed that to increase expediency by focusing on actual humans that are custodians of the documents or the records. So I think we want to get some clarification on that, and I didn't quite see that in our legal counsel's review. So that's all the questions I have right now. Thank you, Mr. Cote.
Member Hensey, do you have any questions?
No.
Maybe we could take a moment to discuss between us.
Mm-hmm.
At this point, I don't see direct evidence of the city attorney counseling in order to avoid compliance. I see a memo that shows what compliance means, but I think that we've seen cases like this in the past, and the request of the city attorney was not, how do I get out of complying with this information? The request of the city attorney from that memo appears to be, what do I need to do? Like, what laws do I need to be in compliance with? And we have required specific evidence to show that the city attorney's office was acting upon a request to avoid compliance, to avoid the release of information. So I was wondering what the members of the committee have, what thoughts you have on that issue and how we can handle it in this case.
Well, I'd like to ask Mr. Hartz a question then for clarification as to specifically what do you feel was being withheld that was outside the scope of their advice?
Basically, all of the information related to exactly what amount of money that the Friends raise in a particular year goes to support the library and where the other money goes. What the documents that I have been able to get show that 90% of the money is unaccounted for. They spend it on their own operations or whatever, and there's really no telling. And by giving the library the direction that the Friends does not have to comply with the entire ordinance, they're basically saying it's okay to withhold information from the public regarding money that is donated by the public, supposedly to support the library, but eventually, from everything that can be seen from what's available, it does not actually go to the library.
Okay. So the question, I'm a little confused. So are we talking about the library or the Friends with regards to this?
Both, because it's a fraud. They're colluding to hide the information about how much money goes to the library. For years, they came in and they would say, "Oh, we gave this amount of money." Well, then I said, "Well, yeah, but only half of that actually comes from the Friends. The rest of it is from outside donors, and you're taking credit for it." And so basically, what I'm saying is, the Friends could come in at any point in time and show that all the comments I made at public library meetings are false or inaccurate or whatever. They have never done so. They have the information, and I believe the part of the law, part of Casey says that if there is information that one party has that another party does not, and that party who has the information could produce better information, it is justifiable for a jury to doubt the word of the party that's not giving the information they could. The Friends could at any time release information and show that I am wrong and that all this money is not being spent by them on them, and much more of it is going to the library, but they don't do that.
The concern I have about this is that the Friends is a 501c3. They are not a city agency, and so
they are using city resources. If you go right now to the city's website, on the front page, there's the Friends of the Library and a link to them. They're being steered there by a city agency, told that this money is going to support the library, and it's not.
I understand that, but the entity itself is not a city agency, whether they get use of city resources or not, because there's a lot of nonprofits that get that, but the application of Sunshine for a nonprofit is under 12L. It's not under under Administrative Code 67.
Well, honestly, all these years, the library and the Library Commission could have asked the Friends for this information themselves. If I get up and call you a fraud, I say you're committing a crime, and you have access to the information, and all you have to do is ask the Friends, give us information that shows Mr. Hartz is wrong, they could do that. And the library hasn't done that because they can't, because I'm not.
Okay.
And so basically, I think it's parsing, it's how many angels can dance on the head of a pin to say that there's, it's a 501c3. That's like the Library Commission saying, we have absolutely no responsibility, although we have authorized this group of private individuals to raise money in the name of the library. We have no obligation at all to find out whether the library is actually benefiting from that, and if so, to what extent.
I understand. Again, there is a definitive line between a public agency like the library, the Department of Library, versus a 501c3 that may support it, whether by donation or special relationship or what have you. Now, they may be a supervising agency for them, like if they had a special agreement or a written agreement or a contract or something like that.
They do, and it's been before this task force.
Right. But the requirements for disclosure of information is different than it is for the actual public agency that's being funded with public money. That's why 12L was created, because they're a private corporation, and so there's a level of financial and ethical firewall that they have to have as a business from public government.
And so what the library is positing is that we have absolutely no responsibility to know, even though we're endorsing this, we're allowing this, we're authorizing this, we're participating in this, we're supporting this, we have absolutely no legal fiduciary responsibility to know whether or not what we're saying to the public is true.
Okay.
I have a question for our members, kind of taking a step back.
Thank
So this complaint was in regard to memorandum written by the city attorney's office to the library. The request was when there's a reference made to the gift agreement, which has to do with funds that are being given to an organization. Is the law requiring a compliance with the Sunshine Ordinance or with the gift disclosure requirements of the city's administrative code? And what this memo was saying was interpreting that the agreement requirement had to do with the gift disclosure, compliance with the gift disclosure rules, not with the Sunshine Ordinance. Looking at what the request was of the city attorney's office, the request of the city attorney's office was not to, based on the documentation provided, was not to find out how to not comply with the Sunshine Ordinance, but whether the agreement requirement had to do with abiding by the Sunshine Ordinance or abiding by the gift disclosure requirements of the administrative code. And so I think that that's kind of where we need to focus on in our analysis here. To further that, looking at the Sunshine Ordinance, when we look at the provision for 6721I, that the San Francisco City Attorney's Office shall act to protect and secure the rights of the people of San Francisco to access public information and public meetings, and shall not act as legal counsel for any city employee or any person having custody of any public record for the purposes of denying access to the public. So I feel like our focus here, like what we should be analyzing are, do we have all of the facts and evidence in place to support a claim under 6721I that the city attorney's office was acting as legal counsel for a city employee to having custody of public records to deny public access to those records. And from what I'm seeing from the evidence in the record is that this memorandum does not meet the facts and evidence requirement for 6721I. What I would be looking for in this case would be something like records from the requester, the department, for example, asking, we have this information, what do we need to do in order to not release it? And the information in question to me doesn't meet that standard. I'm curious as to what the others think, what evidence, but right now we're trying to figure out, do we have the facts to support this claim or not? Is there something that we should ask the petitioner to provide to support that claim before we can advance it to the full task force? So I was wondering what your thoughts were, if you saw anything in the packet that made you feel otherwise to support 67, a claim under 67.
I think on page 23, there is a rationale that is made that concerns me. It's in the middle of the page. It's titled Sunshine Ordinance. It says, viewing the Sunshine Ordinance as a whole, a court would unlikely find that the agreement requirement was intended to require entities that donate more than $100 to the city to comply with the entire Sunshine Ordinance. I don't understand that statement.
I guess in order to understand that statement, we need to look at the original question that was asked this memo. Because like the way a legal memo is formed is what is the issue at question. And so I did see that sentence, but I had to go back and look what was requested of the city attorney.
But there is a requirement in the ordinance for disclosure on when there are gifts. Now, if this is in conflict with some other administrative code, like some gift acceptance policy or something like that, the ordinance is very clear that the ordinance supersedes that. We weren't talking about a charter aspect here. Okay? So the question is then, is the city attorney applying or providing advice that would or could provide a respondent from not disclosing? And further in that sentence, it says, if the ordinance intended the agreement requirement to mandate compliance with all its provisions, a major policy choice, it would be strange to have virtually buried that compliance obligation in the middle of a section otherwise dealing exclusively with the limited. It's so subjective. Trying to split apart very specific aspects of a particular provision. The entire ordinance applies at all times.
Madam Chair, I would like to state that there is currently an open complaint with the Sunshine Ordinance Task Force regarding this very specific issue. The task force was not able to make a decision at this time, and we're just waiting for additional information before rescheduling that specific matter regarding the compliance with the.
Is this with the Opera House?
No, this is with the public library.
Okay.
This issue is the very specific issue with this memo is still pending before the task force.
Under a different
Complaint
petitioner?
number. Same petitioner.
Same petitioner, but one is a complaint against the library and one is a complaint against the city attorney's office.
Yes.
Okay. Yeah, so my issue here is, for this, since it's specifically to determine whether the city attorney is providing additional or other information that might, other than just global advice, to provide a way for a respondent to not comply by either pitting one section of the code to another section of the code, or to try to split hairs and make it seem like that some parts of the ordinance apply but others do not. That I have some issues and problems with that. I think the task force should have an opportunity to review that and have some discussion on that. And considering what our administrator had just reported, I think if it's an open question, that we should provide as much discussion on it as possible with advice from our legal counsel.
Member Hinsey, do you have any thoughts?
I agree with Member Wolf that this seems like something that we should get DCA COLA's opinion on before we.
In addition to what was provided in the packet from.
Yeah.
Okay. Do we have any motions at this time?
Well, I moved to find a jurisdiction. There's no records here necessarily to apply as being public or not. I'd find jurisdiction and to schedule it.
Sure, I'll second that.
Do we have any public comment on that motion?
Just to restate, that motion is to find that the task force has jurisdiction and to forward it to the full task force for hearing.
Do we have any public comment on that motion? Seeing none, can you call the roll?
Member Hinsey?
Aye.
Member Hinsey, aye. Member Wolf?
Aye.
Member Wolf, aye. Chair testifying?
No.
No.
Oh.
Motion passes. Sign.
Can you call the next item, please? Thank you.
Item number 5 is file number 17087, complaint filed by Ray Hartz against Mayor Edwin Lee and the Office of the Mayor for allegedly violating Administrative Code Section 6731 by failing to administer and coordinate the implementation of the provision of the Sunshine Ordinance for departments under the control of boards and commission appointed by the mayor.
Do we have anyone present on behalf of the petitioner?
Madam Chair, before we get started, I did have previous conversations with Mr. Hartz on the possibility of amending the title regarding the name of former Mayor Edwin Lee.
And what would that change be?
It would just be a complaint against the office of the mayor instead of a specific mayor.
Okay.
And I would.
At this time, I see it does say Mayor Edwin Lee and the office of the mayor. So I don't think we have like a notice issue about.
No, there's no
deleting
notice
that
issue. It's
because
just a matter
both
of
have been.
If we should remove the name or not, I would like to get confirmation of that.
I have no objections to that.
Yeah.
And I think it's in the interest of the petitioner who filed it and named the respondents.
Do we need to take a motion to make that change, or can we?
No need. We can make that change with the agreement of the parties.
And does the petitioner agree?
Well, he's the one that proposed it, I
Okay,
thought. Yeah.
great.
Can you give the petitioner 5 minutes?
Members of the Complaint Committee, Ray Hartz, Director, San Francisco Open Government. Again, we see the list. If I can get the overhead back on.
Go ahead.
Where'd he go?
Go.
You have me start the clock.
Used to be a nice little button over here. You could just push it and it would.
That's what I'm trying to find.
I'm sorry.
I did.
Turn off the clock.
This is the same list that I showed in the last complaint, and the reason I'm putting it up again is because it relates to the public library. And again, the same 10 violations, a finding of violation by the task force are indicated in red. And I want that, to be very clear that, we've got years, literally, of the San Francisco Public Library violating the Sunshine Ordinance, determined not by my claims, but determined by the task force in its own findings. And I think this is a pretty clear-cut issue. Section 6731 says, the mayor shall administer and coordinate the implementation of the provisions of this chapter for departments under his or her control. The San Francisco Public Library is under the control of the mayor. The city librarian is appointed by the mayor and serves at his discretion. It goes on to say the mayor shall administer and coordinate the implementation of the provisions of this chapter for departments under the control of boards and commissions appointed by the mayor. Every single member of the San Francisco Public Library Commission is appointed by the mayor and serves at the mayor's discretion. So obviously, and this is where I brought this complaint once before, a few years ago, and they wanted to make it into a complaint that it is not the responsibility of the mayor's office to enforce the rulings of the Sunshine Ordinance. And I was never arguing that. What I was arguing and what I'm saying, what it clearly says in the law, it is the mayor's office's job to ensure that the boards and commissions and the departments that fall under the mayor's control follow the Sunshine Ordinance. I don't think the reading could be any less ambiguous. it says the mayor is responsible. And yet we have a particular department, the San Francisco Public Library, who on 10 occasions has been found to have violated the ordinance. And yet there has been no attempt by the mayor's office to do anything to get them to follow the law. And very frankly, why would they follow the law? I think it's very similar to what the civil grand jury said about the San Francisco Ethics Commission in their report called was it Sleeping Lion? Or whatever, where they said that the city agencies are encouraged to ignore the Sunshine Ordinance because the Ethics Commission doesn't enforce it. And I'm saying in this particular case, the San Francisco Public Library is encouraged to do whatever they want and hide public records, withhold public records, stifle public comment, interfere with public comment, because they know the mayor won't do anything to enforce the law, to make them do what they're supposed to do. And I think at some point there has to be a recognition of the fact that if the mayor turns a deaf ear and a blind eye to repeated violations by the same organization, one he controls not only by being in charge of the department head, but by being in charge of the entire body that supervises the department, then there's a real question there as to whether or not the mayor is willing to follow the law and to order the departments under his control to do so. I mean, can anybody read that and say it is ambiguous about what the mayor's supposed to do? He's supposed to administer the law. And in this case, it relates to a department and a commission that both are solely serving at his discretion. I just really cannot find any reason why there would not be a violation, because obviously they continue to break the law. They do it over and over again for years, and the mayor's office is silent. And I'll tell you what my personal belief is, and I'll clearly make that personal belief. The information that I'm trying to get and the information that I'm trying to talk about at public meetings is information that the mayor and the mayor's office wants even more than the library to keep hidden. He don't want anybody to know that this scam has been perpetuated and perpetrated on their watch.
Is anyone present on behalf of the respondent, the mayor's office?
Good afternoon.
One moment, Mr. Lim. Can you give him 5 minutes on the timer? Thank you.
Good afternoon, members of the task force. Victor Lim, former Deputy Communications Director with the Mayor's Office, now with the Department of Emergency Management. You have in your packet here on page 60, we submitted a response August the 11th, 2017. And so we asked that the task force should dismiss this complaint because, and I'm not going to read all of this, but basically with regard to the 2 additional orders of determination included in Ray Hart's updated list attached to a complaint of this case, and I'm reading off of bottom page 62, third page of the response. I'm going to skip all that. We understand that the case of 16087, the library procedure, or produced all responsive documents in its possession, but the task force found a violation based on the library commission secretary not inquiring with the commissioners regarding whether they had responsive documents. And then it just summarizes, but basically the important thing is this. So what if the mayor agrees with some or not all, but does not regard them as sufficiently serious to warrant such taking an action against the city librarian or library commissioners? Under the both the ordinance and the charter, the mayor is free to make those discretionary judgments without being found in violation of the law. And then we go to the very end. So the above recitations, I'm going to skip all that on page 3. So the above recitations of the facts illustrated illustrates the weakness of the foundation on which Mr. Hart's bases his complaint. For most of the orders of determination cited, the library has acted in a manner consistent with the advice of the City Attorney's Office, the judgment of the Ethics Commission, or usually both. To leapfrog from those facts to a conclusion that the mayor has failed to comply with Section 67.31 by not taking some sort of action regarding the city librarian or library commissioners is a stretch that strains credulity. The remaining orders of determination cited, as explained above, are few in number. In one or more cases did not involve a violation by the city librarian or library commissioners. Involved facts that at worst were in legitimate dispute and even in the task force views were not considered willful violations. For the reasons stated, the task force should dismiss Mr. Hart's complaint. And it's as you understand, since it's been filed, Mayor Lee has already passed and left us, and City Librarian Mr. Herrera has retired. And we've also spoken with the city, with the public library to ensure that they have taken adequate mechanisms to make sure that they follow the Sunshine Task Force and to prevent any misunderstandings or any alleged violations.
Thank you. Do we have any questions from the task force members? Member Wolf or Member Hinsey?
I have a question for the respondent, Mr. Lim. You stated that the mayor cannot be found in violation of law because they are they operate at a level of discretion. Is there some citation that you can provide that in the charter that allows for that?
I don't have that to provide for you at this moment.
It would be helpful as part of your defense to cite a section of the charter, because the ordinance is pretty clear that that the mayor shall do this and shall do that to make sure that the ordinance is complied with under the executive branch. So if there is something some section that would be helpful for us, information to clarify, for that. The other thing is are you aware in the mayor's office, and frankly, with all due respect to the former and the passing of Mayor Lee and the retirement of Mr. Herrera, this complaint was brought at the time when they were still around and available, and I think it's in the best interest of the ordinance and the public that we understand whether it was applied properly or not, and having that discussion and letting the task force make a decision on that. Be it as it may, are you aware of any specific process in the mayor's office for training and assuring that the executive branch is fully aware and educated about how to implement the ordinance?
So just to be clear, I'm back just for this response because I'm no longer with the mayor's office as of Friday. That was my last day. But prior to my departure, we had spoken with the library. They, as our understanding is that they have set up an independent system in place, mechanisms with staff members and their own custodian records that respond and submit records to requesters for any public records. It has always been our policy that we do not oversee the other departments for the requests. But in any case, given the situation of the transition, we have taken mechanisms to ensure that during this transition process, whoever my successor is for the custodian records, and at this point, my colleague Tao Quitone is the system of records until we transition into Mayor Breed's administration, to ensure that if there are questions, the library, the public library system will contact the mayor's communications office.
Thank you.
Thank you.
Member Hensy, do you have any questions for the
no.
petitioner or the respondent?
No.
Thank you. I think at this point we can take it inward for some discussion. Do you have any thoughts on any facts or evidence that would be needed in order to round out this complaint before it can go before the task force?
I would say if the mayor's office has written communication or any kind of procedure or policy, internal policy, with regards to how they implement or instruct the rest of the executive branch, that would be helpful. And also just, the lack of a citation, that's kind of makes it a little more
Right.
difficult.
At this point, do you think this is something that we could request of Mr. Lim to provide the written form of the policy and vote now to allow this item to move forward for dispensation before the full task force? Do you feel comfortable with that? Member Hensy? Do you feel comfortable with that?
Mr. Lim,
Yes, ma'am.
given your new position, are you able to do what we're asking?
So what I can do is this: bring this message back to Mr. Quitone and have him follow up with the communications office and check on the policies. And this also, as you understand, we are in a period of transition. Okay. July 11th, we will have the new mayor sworn in. And at that time, there will be new staff in the communications office. So if, there should be development, if it may depend on what the new administration plans to take on. But we have, as mentioned, the policies in place, but we'll try to produce it.
To get the written version. Yeah, you've already mentioned that the policies are in place. It's just us getting a written copy of that.
Yeah.
Okay. So I think that what we could do is vote on this item now as we see fit and calendar it for a period perhaps in August or September when the transition time seems to be finished, and so we can get.
I would also add and also provide citation for the claim that that this would be at the mayor's discretion and not a requirement.
Do we have a motion?
So I move to find jurisdiction, and that the mayor's office will provide the information as we discussed with regards to the implementation or policies or guidelines, whatever they have in writing to the executive branch and its departments, and to provide a citation supporting that the mayor acts as discretion and cannot be found in violation of law.
Do we have a second? Okay. Do we have any public comment on that motion?
I think what Ray Hart said
Carol, time.
about the mayor's office is very true. It's been my experience. If you go in there, you're actually treated with hostility. If you just ask questions, can I talk to somebody who's in charge? I was just escorted out. I went there once, and there are no phone numbers. You can't talk to anybody. So it's a very mysterious thing. And I'm pretty familiar with the charter. There is no citation where the mayor has sole discretion to do whatever he wants. There's nothing there.
Thank you. Do we have any further public comment on that motion? Okay, seeing none, please call the roll.
Member Hensy.
Aye.
Member Wolf.
Aye.
Chair Tesfaye.
Aye.
The motion passes.
Thank you. If you could call item 6, please. And actually, I would like to make an announcement. So items 6, 7, 8, 9, I think that's 11, 10, and 11, and 12, all concern the same code sections of the government code and the administrative code. And so we will be listening to these items, or I would like to propose that we listen to these items at the same time because they contain the same law and fact pattern. I would like to hear what my fellow members think of that proposal.
Sounds fine to me. Sounds fine to me.
My only question is if there's any difference in the the facts with regards to the request or the alleged violation for each of the by the same petitioner for each of the respondents.
I would like to state that originally when we received this complaint, it was one complaint listing separate respondents, and it was at our discretion that we separated it into separate complaints so that it would be a different one against each respondent in case you had different findings against the various respondents.
Right.
So it was originally submitted as one original complaint.
Okay.
I guess my question could probably be to ask the petitioner if there's any one of these that is different than the others so we can determine which to group together or not.
Yeah.
Is the petitioner available? Mr. Amos?
Thank you, members. I'm Reverend Townsend, Arnold Townsend. I am not Dr. Brown. Dr. Brown contacted me very late this evening after 4 o'clock. He had an emergency, and I would request that you delay this, put this over until a future meeting. The only thing I would say that I am the vice president of the San Francisco branch of the NAACP, and that our national convention is in San Antonio from July 14th through the 18th. So if you were going to schedule that, you not do it through those days because we'll all be out of town once again. But I would ask you to put this over, and the advantage in that is it will greatly shorten your evening. Okay. So, thank you.
Reverend, so Mr. Brown had contacted you personally?
Personally, this late today.
Okay.
Since Reverend Townsend is also a member of the organization, I leave it at your discretion if he is also authorized to make that request or not.
Okay. Members, would you be willing to move this item to another agenda?
I don't have a problem with it. I mean, we're just here in committee to determine just basic facts and evidence to determine whether this should move forward to the full task force or not. Let me ask, if I may ask Reverend Townsend a question. Are you familiar enough with the issue?
No.
You're not? Okay.
No. This is not the area that I am responsible for within the organization. So I really would not feel confident representing this item.
Okay.
In that case, I'll move to continue this item to the call of the chair or to a future meeting.
I believe there was I had discussion with the chair of Chair Wolf regarding a possible scheduling of this on a non-Tuesday and possibly doing a special meeting of the complaint committee on August 1st prior to the full task force meeting.
Which is on the 2nd?
It's on August 1st.
So
we would hear it at 4 o'clock as a special complaint committee meeting, and then as soon as that was over, we would convene the full task force meeting.
okay.
I don't know. I leave it to your discretion on whether or not to select that date or not.
What date would that be again?
August 1st.
Wednesday.
Yeah, for the purpose of what we're experiencing here today, there, you know, we're here on the same day and time as the Board of Supervisors meeting, and it makes it difficult.
Oh, right.
So, unfortunately, this is the date that City Hall provides us. You know,
The room.
right? The only other day that's different, that's not in conflict, is our regular meeting. So,
I may have a conflict that date. I think we should also probably hear from the respondents if they're
Yes.
present.
Yes,
on
they
that.
would like to make statements from the looks of it.
okay. Thank you, Reverend Townsend.
All right, thank you so much.
We're going to hear from the other respondents to see about this matter.
Thank you so much.
Thank you.
Please state your name and your office, if you don't mind.
Of course. Amy Beinard, legislative aide to Supervisor Hillary Ronen. And so thank you for convening this, and I do appreciate that you understand that none of the members of the Board of Supervisors are here tonight. I don't think that the board meeting is quite over yet. But I did want to point out that that July 31st is the last Board of Supervisors meeting before the August recess of the Board of Supervisors, and so I suspect that many of the members of the board may already be out of the office, out of town on August 1st. So I'm wondering if you can find a date that works.
When do you reconvene?
They reconvene mid-September, sometime in that range,
I think right after Labor Day. I think the first meeting
after
is...
the holiday.
Okay.
So
Yeah, I
maybe,
can tell you that.
Actually, it might be good to push it because we're going to be very short.
Staffed ourselves.
Well, yeah, we're not going to have. We're probably going to have just enough members to make quorum. So until we can have the new administration installed, the new president, and if there are any new appointments or adjustments to this position, the Rules Committee needs to convene and approve appointments. So
I really appreciate you being flexible on this. Yeah, the first meeting of the Board of Supervisors after August is September 4th, which is the day after.
So I would like to propose that rather than schedule this at this moment, we've heard feedback from the supervisor's office and from the petitioner, and we could take into account the NAACP conference. I would like to also hear if there are any other respondents that have any concerns with scheduling.
Good evening, Marty Fatu, Office of Supervisor Jeff Sheehy. In terms of the scheduling of this item, Supervisor Sheehy will no longer be supervisor as of midnight, July 10th. Supervisor-elect Mandelman will now be representing District 8. So I was just conferring with the petitioner's representative, the Reverend Arnold Townsend, whether or not it would be appropriate for someone from our staff or the supervisor to have to reappear before this committee because now the supervisor will no longer be in an official capacity. So if somebody could answer that question, that'd be great.
I think that's a question for Victor.
I have a question. Did your discussion with Reverend Townsend as to whether the complaint against Supervisor Sheehy would be withdrawn?
No, we just were just speaking just a moment ago.
Okay.
I just had asked him that question, but I mean,
I think that's really up. I think it's up to the complainant, to the petitioner, if they find that there's because he's going to be leaving office at that time, whether they want to continue with that complaint.
Okay, so then it would be up to Supervisor Sheehy to reach out to Reverend Brown then on that, or
so.
how does this? Or
I don't know if Reverend Townsend is in a capacity to do that right now. But
Simply what I had said was that I will certainly pass this consideration on to Dr. Brown and see what he says about this. Obviously, Supervisor Sheehy reaching out would, I think, be a good idea, and we would see what happens from there.
Thank you.
We will follow up on that and provide response.
Okay. Thank you. Do any other representatives of the respondents' offices have any comments on this matter?
Supervisors. Any
Supervisor's
other supervisor office? No?
Okay.
Through the chair, I would just ask that either one of the parties contact staff, our staff, to make sure, what the response is with regards to...
Yes, we will send out emails to all the parties regarding potential meeting dates to make sure we can find a date that works for the majority of the parties.
Okay.
Thank you. Do we need a
Yeah.
Yeah.
Hi, I'm Noelle Young with Supervisor Jane Kim's office. Thank you so much, task force members, for allowing us to give some commentary as to whether or not the item would be heard tonight or at a future meeting date. Just curious to know, for the record, would you like to know who is here in the room in terms of respondents? Just curious.
That would be great.
Okay, so Supervisor Kim's represented by myself, Noelle Young, just for the record.
Charlene Choi representing Supervisor Norman Yee's office.
Nicholas Persky representing Supervisor Sandra Lee Fewer's office.
We got it.
I think we have heard from all of the representatives, and for the record, I know Charlene Choi from League of Women Voters work, and I don't think it would inhibit my capacity to work on this matter. So I'd like to make a motion to have this item be left to the call of the chair, and we'll work on scheduling. Do we have a second for that?
Second.
Do we have any public comment on that motion? Seeing none, can we take that item by acclamation?
No objection.
No objection. Great. Thank you. Thank you all.
Next item.
Next item.
Item 13.
Item 13, I'm sorry.
And if
Item
members...
13 is announcements, comments, questions, future agenda items, pending calendar by members of the committee.
I have one.
Great.
We have a new president of the Board of Supervisors. It's Supervisor Malia Cohen, who will be serving probably just through the end of the year. She doesn't take office until January. I think it's the second week of January at the Board of Equalization. But most likely it'll probably be just through Thanksgiving because nobody's ever really around in December. So
she may win the vote again.
Right. They'll have to vote again. That's right. Okay. And that was a unanimous vote, by the way, of the Board of Supervisors.
Just today?
Just
half hour ago.
Yeah, 30 minutes ago.
Thanks for that update.
Okay.
Do we have any other announcements?
Move to adjourn.
All right. Second, yeah.
Thank you.
The meeting is adjourned.
Thank you.
4:55.
Thank you.
Please stop the recorder.
Mm-hmm.
To swear.